The will can be a little complicated depending on who you're listing and your family dynamic, but the living will is just a weird document to walk through. Although I feel like physicians know that better than like for someone who's not a physician, I'm like, yeah, you want to do what with a feeding tube? For how long?
Welcome to the Physician Sense Podcast, a podcast designed specifically for physicians, offering a breakdown of complex financial topics to help you develop your financial IQ, further your financial journey, and improve your well-being. Whether you're a medical student, resident, fellow, or attending physician, you're sure to learn something new that will benefit your journey. And now, your hosts, Chad Chubb and Tyler Olson.
Welcome to this episode of the Physician Sense Podcast. I am your co-host, Tyler Olson, and I'm joined by two people, not only my lovely co-host, Sunshine State advisor and friend, Chad Chubb. Good to see you, man.
Always a pleasure.
And we're joined by a guest. We're so happy to have you, Kyle, with us. This is Kyle Claussen. He is the founder and owner of Resolve. And we've talked with you, Kyle, about physician contracts in the past. And we're going to talk about something else. Anyway, it's really nice to have you. Thanks for coming.
Good to see you guys.
Our first repeat guest.
Yeah. All right.
Oh,
What are we at? We're in like the 40s, right? 40 episodes in?
This is 41.
All right.
And Kyle's done it twice already. We got to send you like a crown or something.
I like it.
So I was so excited to be able to talk with you last February when we met up to find out that your firm does estate planning too.
Yep.
On a national level. Oh, I was so glad to hear that because it is really hard to find an organization that can support that. And so we wanted to talk about estate planning and like how that plays into like asset protection and, end of life decisions and all that, and how physicians should be thinking about this.
Sounds great.
You do both. You are you do the physician contracts, of course, but the estate planning. Have you been like? Is that is it like kind of like you could do either one at any given day, or is it like sometimes a year it's like busier with one type versus another?
Well, I think from like a seasonality standpoint, a lot of the physician contracts renew in July for, kind of obvious reasons. That's when they leave training. And so there's this cadence around, either getting a new contract or transitioning from one job to the next, where for us, that means winter is usually busier, right? Like October to March is kind of our heavier time. Estate planning, and asset protection, that just tends to come up whenever it comes up. So there's really no season on that. It's and with estate planning, it's usually whenever someone's coaxed them and reminded them enough times, because it's not something that people like to do. They don't really rush into like, hey, I've got to go get a will or I've got to put a trust in place. It's usually from guidance from folks like yourselves or somebody else, a family member, or life event that happens that'll trigger that. So no seasonality around that stuff.
Nobody likes to get it done.
Mm-mm.
No, I haven't met one person that's like, oh man, I've been waiting to do this. The statement that they come up with, it's like, I have to do this, right? I know I should do it. I put it off for 5 years type of thing.
Yeah, that's the truth. One question that I wanted to ask you.
Sure.
When do you think is the first time that a physician should typically be looking into investing in estate planning? Like from a career or life perspective.
From a life perspective, I mean, I think if you have kids at all, right? I mean, that to me is a pretty obvious one. When you talk estate planning, I think what sometimes people don't understand is that there's a default plan for you, right? It's called dying intestate. Every state has their own set of rules of this is where your assets are going to go. And so if you're single, it's probably going to go back up to parents, right? And then down to your siblings. If you have a spouse, it's probably going to go to your spouse, right? In almost every scenario. So there's not a ton of risk on that. It doesn't mean that it's clean from an administrative standpoint, because you have to go through probate and get all these people appointed and do that kind of messy work. But I think if you got kids, right? I mean, there's other things of who's going to take care of them. When all of my assets are now liquid, right? Like when do my kids get access to those things? A lot of times 18 is not the right number on that. And so I think from a personal standpoint and from, I think, most physicians' standpoint, as soon as you have a child, you ought to be thinking about doing this.
Yeah, definitely. To that point, like with a kid, It's very problematic to have a term life insurance policy say, you're married, your spouse is your primary, your primary beneficiary. But in the event that both of you died, the contingent beneficiary, I so often I see like the 7-year-old kid as the beneficiary. And is there a scenario in which just a will is enough to be able to navigate around that? Or is it like you got a kid, you got a life insurance policy that's going to help provide for them, you need a trust? That's where my mind goes. But is there ever a reason why someone would not need to have a trust done?
Well, I think it depends on type of trust. So I think what you're thinking about is like a revocable trust, right? You create it.
I am thinking about a revocable trust.
Live right now, right? You can have like contingent trusts or these trusts that just spring to life baked inside of a will, right? And so it's okay to have a will or to try to keep it as simple as you can from a titling of asset standpoint and still have contingencies built into that, a young beneficiary trust for a young child to still account for. I think the next question you're going to ask is like, let's say it's a term life policy for $1 million. Does a 7-year-old, should they have access to that? Can they have access to that? If they can't at 7, should they at 18? I mean, I shouldn't have had $1 million at 18, right? Most kids probably shouldn't. And so, I think that's the planning part of it is like, how do we protect the child financially? Let them mature so they can make better financial decisions and to have somebody else help from 18 to 25 or 30 or whatever that financial maturity age is. You can do that inside of a will. You can do it inside of a trust, in either of those, but it's not your cookie cutter template, right? Like will offline probably that's going to do that. You're going to have a little bit more of an advanced plan to get that done.
To build on that question from Tyler, Kyle, what happened? What's the difference between, let's just say again, mom and dad go on a trip, things don't go well, minor is set to inherit, all mom and dad's money.
Yeah.
What's the difference of process between listing as your contingent, your estate versus the minor? I feel like I've actually asked you and your team this like 20 times and I still like always have to come back to get, and I know what the answer is, but I want to hear you describe it for the audience. What happens in those scenarios? Like, why is that important?
Yeah. So, I mean, if you're listing the individual, it's very clear, right? Like it goes to the 7-year-old, right? Whoever that is. If you're listing out the estate or you're listing out a trust, well, then we have to go to that document to figure out what does your trust say? What does your will say? What is what is the estate supposed to do, right? And so, a lot of times, if it's just the estate in general, right? I mean, if you have 3 kids, it's going to go 1/3 to each, as opposed to if you're listing out one child or in a beneficiary form. So there's slight differences there. We like to, if we're getting to the minor, right, kids, we'd rather have it flow into that trust so we know who the trustee is of it. We know when the triggers get pulled and when they actually receive distributions. It's a lot cleaner than trying to say 25% to all 4 kids, right? Without those rules in place. So there is some nuance there on what you do with beneficiary forms.
Does listing the estate give, the attorney that's kind of going through the probate process, does it give them more options than listing just like one minor or numerous minors? Or is there not a huge difference there?
Not huge. I mean, the attorney or whoever's running the probate, right? I mean, has to follow the rules, right? So if they died intestate without anything, they have to go to the pecking order. If they die with a will and it says, here's my 5, whatever beneficiaries on this thing or people that I want to receive assets, they've got to follow that rule. So I don't know that it gives them more options necessarily, but anything that has a beneficiary designation it's considered a non-probate asset. So you can pass those without going through the court process, right? Which makes it more efficient. So there are times when like just listing a person on a beneficiary is better than saying the estate, right? For that reason. But anytime it's a minor child, I want it to go into that trust that we created, that we planned for, that we talked about, right? And not leave it up to potentially, right? Maybe an attorney not making the right read on it or a child getting it too early at 18. Those are the things that we want to try to avoid.
So by listing an estate, assume that they have a will or trust in place, a state will allow it to get into that trust compared to if I just list my boys outright, it might not ever get to that trust.
Correct.
That's a pretty big deal.
I feel like that's one of the more common questions. That's why I like that question, Tyler. That's why I wanted to throw it in there. Because I feel like that's very common, especially with, where our clients, the bulk of our clients' ages fall, like these documents are getting drafted and that one comes up quite a bit. And just, I know we're talking about estate planning, but the amount of times that beneficiaries are not organized appropriately. And it's not something that you can fix afterwards, right? You got to be proactive. You can't be reactive with it. But that again, all just comes back to why estate planning is so important and how that funnels into the beneficiaries. But such like a simple little topic, but possibly completely different routes. And again, at that point, you can't fix it. You're gone.
You're gone. Yeah, that's right. Yeah, that's one of the things. I mean, you can't come in and change distributions for somebody, right? I mean, once they've passed away, if they've got a will in place, right, you have to follow that, right? I mean, unless it's, I don't know, the law has changed, or I mean, there's like a legitimate reason to make some slight adjustment. You can't just decide, hey, Johnny doesn't get this anymore, we're going to pass it over here instead. I mean, that's not allowed. And the other thing that you want to be careful on, if it's a young family, is that it's often true that mom and dad and child, right, are in the same car together. And so we have to think about this really bad scenario of like, what if there are no beneficiaries left, right? What happens to, let's say it's $3 million, right, of term life insurance between me and my spouse if me and all my kids are in the same car accident on vacation, right? And so then if you don't have a will or a trust in place that you've defined who that contingent beneficiary is, now you're back to the state's pecking order. And that's oftentimes where we hear clients go, well, whoa. Like, me and my brother have been fighting for years. I don't want him to have anything, right? And that's the next person on the state's list. And they'd rather have it go to a charity or a church or, somewhere that was important to them or other people, right? And so I think that's another thing to think about. It's not only just kids, it's also kind of that worst case scenario planning.
Yeah, it's a lot to think about. I wanted to switch gears a little bit. No, not a little bit, a lot of it. Because I wanted to center it on like a lot of common questions that I get, but this is very different. I get a lot of questions about the relationship between estate planning and asset protection. And like a revocable trust has no connectivity to asset protection in terms of like creditors and liabilities and all that. Is that correct?
That's right.
So like, what is the connective, or where is the connectivity?
Yeah, I think when people say asset protection, there are estate planning tools you can use, right? Trusts, for example, but there's also business organizations like LLCs you can utilize. There's also insurance products you can utilize, right? There's real estate designations with tenancy by the entirety that you can utilize. So asset protection actually encompasses like 4 or 5 areas of the law, whereas estate planning is just what happens to your assets, right, in kind of a post-death transfer. And so they do overlap, but they're not. It's not like estate planning is the only place you take care of asset protection. If that makes sense.
Yeah, because like we started this conversation on estate planning.
Yeah.
And that is employing tools like revocable trusts and wills.
Right. Mm-hmm.
But trust work extends outside of the umbrella of estate planning into asset protection.
Yes.
Right?
Correct.
So are there, and like, do you delve into that work too?
Yeah.
Okay.
Yeah. So we just maybe we'll zoom out for 1 second on this. So Resolve does like we think of ourselves as like legal tech for doctors, right? So we help out with employment contracts, we help out with estate planning, with entity formation, and so obviously asset protection kind of falls into that. We don't litigate, we don't do other stuff, right? Immigration law, none of that's where we live. But you can utilize trust as part of an asset protection, right, solution if it makes sense, if it's needed. There's a pretty big difference between revocable trusts, which are used to avoid probate, right? And if anybody's been through probate, that's very legitimate reasons to use those, right? It's kind of painful. It's time consuming. It's expensive in some states, and so you can do some of that planning up front to take care of those title transfers and things like that. So revocable trusts are great. Irrevocable trusts, the ones that you can't change, that's where you start to get into the creditor protection. You start to get into utilization for asset protection. And for physicians, that's maybe a little bit different than it is for just your, what I'll call non-physician person that's looking at an irrevocable trust. We see a couple different use cases for it. I mean, some of it's for shielding, right, from malpractice and professional responsibility, things that happen at work. But we also see people as they age start to worry about long-term care. And they'll say, hey, I don't I don't want the nursing home to take all of the stuff that I've worked for, and so they're start to shift that assets into these irrevocable trusts to start to get that creditor protection. So that's where you start to think about how it overlays, is that it's usually trust work shifting assets from one bucket to the next.
Yeah.
Yeah.
So is the look back still 5 years, or did it move back to 7?
So you're talking about for long-term care?
Yeah. So like the look, yeah.
Yeah. So it's I think it's still 5 years. I'd
Okay.
have to double check that for sure. But creditor protection is usually 2. So from a non,
Yeah.
like state aid type of thing for nursing home. And so you have to at minimum be a 2-year on transfer if you're trying to get that creditor protection in an irrevocable trust, potentially longer, 5 to 7, depending on what or who the creditor is probably the way to frame it.
Yeah. We'll get that question every now and then from clients. I'm like, hey, mom and dad aren't doing well. They want to move assets away to preserve some stuff. Like we can do that tomorrow, but don't forget it's a 5-year look back. So it's not like, again, I feel like so much in estate plan and asset protection is proactive, not reactive. Proactive, not reactive.
Yes.
And that's another perfect example of you got to kind of be ahead of the curve a little bit.
Yep.
I had a question about some of these AI-driven estate planning tools.
Mhm.
And there's even like one that we utilize within our firm for some simple scenarios. Do you think that they're useful?
Sure. Yeah. I mean, you can ask the question you want to ask. I think they are useful. I think they're better than nothing.
They're better
Right.
than nothing. Okay.
Yeah. I mean, if you don't have any estate plan in place and you want to go online and get one for whatever, $200 or for free to your financial advisor or whatever, we fully support that. I mean, you should have something in place. Now, are those giving you legal advice? They're not. Are you getting to talk to an attorney? You don't. So it's kind of a canned, usually 20-ish question, right, type of thing. You fill it out and here's your option. That might be okay for you, but if there's any nuance to what you're doing, or they have questions on it, they don't understand it, I think that's what's problematic, right? Sometimes that they're signing off on documents that they don't actually fully understand what they just did.
Mm-hmm.
So yes, I think they're better than nothing. Yes.
Okay. So to follow up on that, then I guess if you were like hypothetically, you find out that a doctor did that, like they went through like a DIY process.
Yep.
And you're concerned. What about their life or business would hypothetically give you concern about them doing something that's like the canned response estate plan?
I think vehicle choice would be my first question, right? Like if they went through and they just got a will because they think wills are what you're supposed to do, and didn't think they needed a trust until they were older, right? Trying to avoid long-term care things, right? Like we talked about, because that's the only exposure they have to the trust world. But they have property in 5 states. What they don't know, because a lot of physicians, right, they like the rental property play and they like the side gigs and they like to do that. And so then they've got 5 properties in 5 states. And now what they didn't realize, now that you actually have 5 probates too to go through, right? So you have your primary probate where you live, but then you have to have ancillary probates going on in 4 other states. And so if they would have talked to anybody, right, who understands that, they could have went from, let's say it's a $300 online will to maybe $1,500 or $2,000 of trust work, but they're going to save $20,000 or $30,000 of probate fees later on, right? So it's like a 10x win for them financially. Yes, they have to pay it now versus when they're gone, right? But it's still, if they're being prudent and they want to be in this financial space, that's a pretty big mistake to make. So that would be one example, but there's probably 100 others, right, that are out there of like, hey, the 20 questions might not have covered your full situation. You might have wanted to ask 30, right, before you made a recommendation. And the software doesn't always do that.
5 probates, that sounds terrible.
Yeah, we don't want to do that. No.
Just to piggyback on, I know we noted the will, but because I feel like there's always one. I think a lot of people are scared to contact an estate attorney because they think it's going to be like $10,000 for a basic estate package. So 2 questions in here for you, Kyle. One, we talked about the will. What else do you consider like the base package that most people, especially anyone with a kid, should have, tomorrow, sooner than later? And then on average, I know it's tough, right? Because everyone's going to have, do they have property in 5 states? Do they not?
Right.
But on average, what does that usually look like in terms of cost, whether that's from what you see in the industry or what you guys are at? Because again, I think one of the bigger barriers is people think it's such a cost prohibitive thing. And I'll do it when I have enough assets type conversation when it's far from that. So those are the two I put in there.
Yeah. So the cost, I mean, most plans are going to be between 500 and like 2,500, right? I mean, somewhere in that range. So is it, really inexpensive? Probably no is the answer to that. But is it going to be $10,000? The answer is also no. It shouldn't be, unless you have a very complex situation, right? There certainly are estate plans out there that are $10,000 plus, but that's probably later career, right? You're doing tax planning at that point. You're trying to avoid, right? Your net worth's over 25, 30 million, that type of thing. The core documents that you really ought to have in place, but powers of attorney, right, for healthcare and financial things, and at least a will, right? You better start there. Now, if you want to avoid probate, if you've got property in multiple states, right, it'd still be the powers of attorney, it'd be the pour over will, and it would also be a revocable trust, right, on top of that. And then with trust work, you've got certificates of trust, and you've got some other things that kind of flow along with that. None of those are, they don't distribute assets. They don't do anything that's that important. It's more like an ID card kind of for your trust. And so you're going to see some ancillary documents with it. But those are really the four probably core documents that most people need, at least early in a career.
Is living will usually embedded in the healthcare POA?
Can be. Yeah. I mean, some states allow for living wills and some don't, but it's all the same terms should be in the healthcare power of attorney. Yeah.
I would say the living will is like the worst form to actually go through. POAs are pretty easy.
Yeah.
The will can be a little complicated depending on who you're listing and your family dynamic, but the living will is just a weird document to walk through. You're like,
yeah, it is. It's all the analytic decisions and
Although I feel like physicians know that better than like for someone who's not a physician, I'm like, you want to do what with a feeding tube for how long?
We actually see more customization on those documents than we do on some of the other ones,
Really?
right? Because they're physicians and they're like, hey, I know exactly what I want into life. And it's not in the cookie cutter form, right? That's out there, which I think is interesting.
That's interesting. That's pretty wild.
I'm so glad that you're here, Kyle, because like it's really like one challenge that I've had, and maybe this is mainly to satisfy my curiosity, but I want to ask you something because a major challenge that I've had over the years in being able to connect with estate planning attorneys is that I've always had to have like a go-to person for like every state.
Yeah.
Why has that been the case, and like why can Resolve do what it does?
Yeah. So just like medical, right? Just like physicians, every state has their own licensing process, right? And so you can certainly be barred in more than one state, right? Which allows you to practice across that. And I think that's probably what you've been running into is that if you've got a contact in Charlotte, let's say, right, they're probably barred in North Carolina, maybe a neighboring state, maybe not. And so they just don't have enough volume to make it worth their while to go outside of those two states, right? That's my guess. Whereas our business model is we want to cover the entire country, right? So we have people that are licensed in multiple states, and or if we don't have that state covered, we have co-counsel. Like we've done the heavy lifting for you, right? And have that ability to go out and connect. So I think it's just business models are different on what people are after. We very much value flat fee transactional work, and we want to do that for a very specific niche across the entire country. And so we feel like we have to do it that way.
That's really cool. Yeah. I'm glad you decided to do that because that's a major pain point for financial planners is being able to
Sure.
I mean, we have our networks of professionals, but like to have like 50 estate planning attorneys in our Rolodex, so to speak, it's like, can we not, please?
Yeah. Well, and people move, and it's just, like on the employment contract side, I mean, you might have offers from 3 or 4 different states. And so you can't go out and hire 4 attorneys to look at 4 different contracts either, right? Like you want to have a point of contact and talk across those things, and your estate plan's going to move with you, right, as well as you're going through life. And when you want to pick up that rental property in whatever, Tennessee, right? I mean, you want to be able to talk to the same person that you worked with in Colorado. So that's again, it's not a model for everyone, but it's a model for us.
Yeah. Well, I think that's fantastic.
Just because it's really fun to continue to switch between the two sides here. So asset protection is a topic that I think physicians love the sound of it, and they think that it's so complicated and they love it and they want to get like all these crazy trusts going and family limited partnerships. But for the bulk of physicians, at least early on, it doesn't have to be overly complicated. I'm going to try to limit you to 3. And I know we can touch on different things, right? We can get into the insurance side of it. We can get into asset titling. But for the bulk of physicians, what are your top 3? Like, hey, and I know it can also vary with state, like we get a tenants by entirety, but just keep it high level for me. What are your like top 3 asset protection? Like you should have these in mind or at least research them.
Okay. So we're going to start with their employment is making sure they've got enough malpractice insurance, and they should, right? I mean, that's probably one that they're going to check the box on very quickly, but you need to double check it, right? You should be at least the levels for your state because that's where your highest level of risk is, right? Initially. The second thing I would tell you is if you're in a state that has the tenancy by the entirety, right? Utilize that. It's very easy. When you go to buy your house, it's a box you check, right? It doesn't cost you anything. It's just a choice that you're making. So that's very quick. What that means is that both you and your spouse own the property entirely, right? You own it 100%. So if you get sued, right, they can't take it because your spouse also owns it, all of it, right? And it's a legal, kind of a legal quirky thing that's out there. So those are easy. Umbrella insurance, right? Also very inexpensive and something that they can carry and cover a lot of risk that way. So I would say check those off for sure. And then the last one that I would hit on is you as soon as you get into a rental property, right, or some type of side gig, form it in an LLC, right? If you can, from a lending standpoint, sometimes it's challenging because there's loan to value issues, and right, if you don't have a big enough down payment, you want to buy it in your own name, and can you transfer it to an LLC or not from a lending side? But that'll at least silo off the risk of that rental property from your personal assets, assuming you treat the LLC like you're supposed to. So those would be the 4 kind of the easiest ones. There certainly are domestic asset protection trusts and ILETs and all these other things that you can get into down the road. But I always tell people, walk before you run, right? Like let's cover the most we can as easy as we can and focus on being a good doctor, right? For most of it.
Do you use DAPs most often for the states that don't allow tenants by the entirety?
We use them when someone has a net worth high enough to justify removing certain items from that flexible bucket, right? If I want to invest it and move it around and spend the principal, it's usually for people that are later in their career that say, I've got $5 million that I know I want to go to my kids. I'd love to have the interest off of that for the rest of my life, but I don't want to touch the $5 million and I want to make sure it's protected.
Yeah.
And so we go, okay, that makes sense for that type of trust. If it's just I'm trying to dodge creditors and I still am really young and I want to move around, either one, they're too late to the party, right? They should have done it 4 or 5 years ago, or it's just not the right move for them.
And DAP, for anyone that's listening, that's a domestic asset protection trust. Another fun question that we get quite a bit, because of sometimes the extra hurdles that come with having an LLC for rental properties, what is your biggest fear if they say, no, Kyle, I don't want an LLC, I'm just going to load up extra umbrella insurance? What's your biggest fear there?
I would want to make sure the policy covers that, right? Because I think that there's some misinformation out there and different policies cover different things. Rental properties are, if somebody slips and falls, right, because you didn't repair the sidewalk and it's a child and, whatever, you can paint all these bad pictures of these PI cases that are out there. I mean, the liability could be more than your entire net worth pretty easily, right? Especially if you're young. And so I just think that there's no reason to not do it, right? If you're able to from a lending standpoint, because an LLC is not that expensive, right? And it's pretty easy to have a separate checking account to run the rent through, right? It's not a real active business. It's a once a month deposit. Your insurance comes out. You have property taxes twice a year. It's very simple. And then you're saying, hey, if something bad happens, all that tenant is able to attach to is the equity in that house, which is what it is. And, certainly not the outcome you want there either, but it's better than saying, hey, my entire net worth is at risk. I think it's a no-brainer if you've got rental property. Yeah.
You guys know what my favorite asset protection tip is?
No, what is it?
Date nights.
We didn't talk about divorce.
It's always my favorite go-to. So always has a good laugh too, especially when there's a live audience.
Yeah.
But then they laugh and they're like, oh, that's actually scary that's true. That's always my joke. Physicians always think it's gonna be this big malpractice suit. I'm like, nope. Date nights. Yeah. That's the way to preserve your assets.
Agree. But I'm not a divorce lawyer, so we're not going to go down that
one. Yeah. Yeah. No, we talked about date nights a few episodes back. That was fun, but very, very important. We're actually, to the point of asset protection within that conversation, Chad. I think we also mentioned how, another reason why it's so important to maintain 401k and 403b assets up in the ERISA cloud, because the only thing that can pierce that veil is divorce.
Yeah.
So yeah, got a bunch of, I'm always, not always, but it's very common for financial advisors that are focused on investment management to be looking at old 401ks and saying like, oh, put it into a rollover IRA. We're going to manage it for you. And I'm like, no, like,
Not only does it blow up your backdoor Roth IRA, assuming that's a strategy you're utilizing, but then, asset protection. Again, every state different level of protection for IRAs and Roths, but still, with those qualified plans, you're getting pretty well around it.
Right.
Yeah.
I think asset protection is a really neat topic because it's also it varies by states, but I think people think it's sort of similar to estate planning. Everyone's like, oh, you got to have all these assets and all this wealth before you can get into it. Where in reality, especially for asset protection, just come back to like the 401k conversation. You can have extremely good asset protection by just being smart and keeping your money in qualified plans. So just a fun topic. And Kyle, I think you do a good job making asset protection get excited. Estate planning, not the funnest topic, but you always do a good job, one, explaining it, but two, keeping some good energy in there as well. Because like I said, the living will was not my favorite document to walk through. But it's important to walk through. It's important. I'd rather make those decisions than my wife having to make those decisions. So hopefully she never has to make those decisions. But at least I wrote it out. She knows. Now I'm concerned that I have to go back and redo it since I know all the physicians like customize theirs. I think I just mark like, if I get hit by a bus, just pull the cord and it's over.
So I'll tell you what I tell all the clients. About every 5 years, you're supposed to pull them out and look at it. So it's not a you sign your estate plan once and you just put it away. I mean, I tell people on about a 5-year cadence, review it, make sure the guardian that you chose is still the right person, right? They don't have substance abuse now or something changed, right? Make sure your kids don't have, sometimes, kids have special needs or something happens, right? And all of a sudden it's like, man, we don't want to disqualify them from benefits now at age 18 or 21 or 25. And so we need to change our planning for that. So anytime life events happen or on a 5-year cadence, we think, take a look at it, make sure. So Chad, your homework tonight is go look at yours, make sure it's what you want, and change it if you need to.
I'm still within a 3-year window, but I might have to customize it just based on that. But it's funny, we use, maybe I got that one from you, but we always tell our clients to like 5 years, even just checking in to make sure nothing changed with like the probate process in your state, or like you need to update some wording or something. I mean, those are, again, not an exciting topic, but there's a lot of stuff going on there for you not to take, an hour, if that, to kind of walk through the current stuff. And
that's right.
Yeah, it's important. Again, not the most exciting topic, but vital to say the least.
Yeah. I think that covered my questions. Did you have any others, Chad?
No, that was fun. We kind of came into keeping it open-ended, but I think we covered it really well, especially a push towards that estate planning side. Because I feel like there's so many, especially of our listeners and viewers, that are in that spot where it's just starting to, maybe expecting the first kid or just had their first kid, that you just are like, do I need it? Do I not need it? And again, whether it's the cost conversation or just like, hey, no, it's important for all those reasons we just mentioned. So no, that was fantastic. As always, a lot of fun with Kyle in here. So I think we nailed it.
And if anyone is wanting to like get in touch with Resolve, we'll put your website link in the notes so people can find it. I'm not going to spell it out here because it's the website that's specific to the estate planning. The one I have, at least, it's a little long, so I won't try to have you all write it out. But we'll put it in the show notes so that you can easily reference it and contact them. So yeah, thanks a lot, Kyle, for joining us today. And we really, really appreciate the quality of work that you're doing in the physician space. It is really, really needed.
I appreciate it. Anytime, guys.
Thanks, Kyle.
This information is for general purposes only. This information is not intended to be a substitute for specific professional, financial, or tax advice, as individual concerns vary. Please see a financial professional, CPA, and/or an attorney in regards to your own individual situation. Wealth Deals advisory services and financial planning offered through Vicus Capital Inc., a federally registered investment advisor. Olson Consulting LLC, offering advisory services and financial planning, is a state registered investment advisor.